Respected members, we have assembled here for the MBA in collaboration with the Tamil Nadu Senior Advocates Forum for the continuous learning process, under which today His Lordship Justice P.B. Balaji has kind enough to speak on the specific performance, the road ahead. I want to say a few words about Justice P.B. Balaji. When he was an advocate, when I used to get anything under the Rent Control Act for the CRP, I used to call him. This is the point. After half an hour, you will call me back again, saying that this is the point. Now the bonus information is, he will give some judgment in my favor also. Thank you, my lord. And one more information, today 14/3/2024, we are this bar association is entering 160th year. And for that, small cake is being cut by the Honorable Judge now to mark the commemoration. Cake. When the cake was brought inside the MBA premises, somebody asked me whether it is the birthday of His Lordship. I said his birthday is on 11/4/1973. Am I correct? Yes, okay. So another 27 days are there. Members are requested to keep their mobile phone in the silent mode, please. Later.
If you are not able to enforce specifically what rules are
so far as the MBA Academy is concerned, this academy was commenced on 27th July 2019 by then Chief Justice of Madras, Vijaya K. Tamil, and the first inaugural address was made by Honorable Justice M.M. Sundaresh, the then Judge of Madras High Court. Now I hand over the mic to Judge to speak on the specific.
Very good evening. It's a nice feeling to come back here, like my home turf. And a very interesting topic also. It's always said the brain starts working right from the moment you are born, but it stops when you're in front of a mic. Whoever it is, you may be a public speaker, a judge or an advocate, speaking in court, arguing in court is totally different. But when you're addressing a public gathering, it's a different ball game. But today I won't have a problem because I'm speaking at MBA. Memory and brain get activated here. I think congratulations to the MBA for entering the 160th year. And it's a coincidence that I'm here, one of proud members of MBA. And Mr. Bhaskar, President, just told me that they didn't have time for organizing any function during the day. They had very short time, so they combined this with the lecture. So I'm probably a lucky benefactor to cut the cake and ushering in the 160th year of the MBA, very prestigious MBA. I am ready. Are all of you willing? Yes. But this is not enough. One must be both ready and willing. This is the essence of the topic of today. And what changes have come by because of the Act 18 of 2018, sweeping amendments, substitutions have taken effect, which have come in very quietly unnoticed. Because all of us were doing cases before the trial court, appellate court, high court, and none of us knew, including very famous authors of books. I was killed to boredom during the lockdown. So I thought, I was just reading up articles and on the SEC website and some books. Then I found very important landmark, path-breaking amendments and substitutions had been brought about in the Specific Relief Act, and it had been given effect to on 1/10/2018. Most of us did not notice it. So I thought, why not write a book on the amendment? Because I found most of the books which are available, published even in 2019 and 2020 at the time of lockdown, they never covered the amendments. It was all the old act. The unamended provisions alone were discussed for pages and pages. So I thought, of course, there is no material to write a book on. So I had to write what I felt about the amendments. And fortunately, some of the views I have expressed in the book have been now approved by the Honorable Supreme Court as well, which I will take you through. So first of all, what is specific performance? It is compelling a party when there is a breach, ubi just be remedium. So there is no remedy. There is no, you always have a remedy for a breach. That is the essence of the legal maxim. So therefore, in a contract law, whenever there is a contract, one party is breaching that contract. The normal remedy that was available to the aggrieved party was damages. He can only seek for compensation of money. But the English courts of equity thought that it was inadequate. Compensation by monetary terms was highly inadequate. Therefore, they developed the equitable principles of specific performance, which is a non-monetary relief, where a person can compel, the aggrieved party can compel the party in breach to specifically perform the agreement. So this is the essence of the specific performance topic. Specific performance is only a small facet of the Specific Relief Act. The Specific Relief Act deals with other provisions like injunctions also, declarations, injunctions, but specific performance to me will be the heart and soul of the Specific Relief Act. And what are the amendments? Why the road ahead? Why I chose the topic was, we are in a state of uncertainty, because many judgments have not yet come. Even today, as on date, Supreme Court has dealt with the amended provisions only in about half a dozen cases. So the law field is wide open for lawyers to interpret, for judges to agree, disagree, and develop the law and ensure that the amended provisions are meeting the objects for which they have been brought in. So now let us see I'm not going to take you to the old act. So I'm going to deal only with the amendments, so that briefly you can know what has been intended, what has been done so far by the courts, what is going to happen in future. I'll give you a small statistics. When the Amendment Act was ushered in 2018, 26.5 million cases were pending in the courts of India. 26.5 million cases. And there was a study by the committee to find out how many years it takes to enforce a contract through the court of law. In India, it is 4 years. Average of 4 years to enforce a contract. Contrast to Singapore, it is 164 days to enforce a contract. So the government felt there was an urgent need to revisit the Specific Relief Act to make India an investor-friendly nation, because globalization was happening in a big way. So the central government thought it fit we should not lose out on investors, because they were afraid to invest in India because of long pending litigation, uncertainties in litigation. At the end of 10 years, the court might say, no, you get compensation, we will not allow performance. Therefore, in order to address all these issues and bring in more foreign direct investment and foreign companies to invest in India, the act was proposed to be amended. In fact, there are 3 substitutions and 9 amendments, apart from one insertion of a new schedule. So briefly, I will take you through the specific sections which have been amended. The first section that has been amended was section 6. Of course, section 6 does not deal with specific performance. We all know section 6 is a fast track remedy available to a person who is dispossessed by force, by illegal means. You need not be the owner, you need not be even a trespasser is entitled to invoke section 6 specifically. In fact, it's a fast track remedy, which is an amendment was brought in section 6 by which a person claiming through whom, that is, suppose a tenant has been dispossessed. A subtenant, let us say, take a case of a subtenant. A subtenant has been dispossessed. So under the original enactment under section 6, the subtenant can seek for restitution of possession invoking section 6 of specifically fact. But now even the chief tenant can invoke, because the subtenant claims under the chief tenant. So therefore, after the amendment to section 6 by Act 18 of 2018, even the chief tenant can complain saying that the subtenant was in possession through me. Therefore, I am approaching the court, give me possession. This is the scope of section 6. Now it stands enlarged, including other category of persons who can invoke section 6. The next amendment was to section 11. Section 11, the word may. Section 11 deals with specific performance in relating to trusts. So the word used was may. Now the word used is shall. Therefore, discretion is now whittled down. Discretion which was available, the courts are now widely, strongly whittled down by the Amendment Act. Section 11 may is replaced by shall. That is the only amendment. Section 14, there is a substitution. The entire section has been substituted. So let us see what was section 14 before the amendment. Section 14 before the amendment said, the heading itself was different. Contracts not specifically enforceable. So the Act listed out certain types of contracts, categories of contracts which cannot be enforced. Therefore, if you fall under any of those categories, straight away you are disentitled to the relief of specific performance. First one was a contract for non-performance for which compensation in money is an adequate relief. So if the court finds that compensation can be given in lieu of performance, then don't give performance. So 14A. This vested wide discretion in the courts to assess whether it's called the test of inadequacy or adequacy. You may call it both ways. Test of inadequacy of compensation. If it applies, if it is adequate, then don't grant specific performance is what 14A unamended provision said. 14B, a contract which runs into minute or numerous details or which is so dependent on personal qualification or volition of the parties or otherwise from its nature is such, the court cannot enforce specific performance of its material terms. So let us take possibly a development agreement which involves right from foundation, basement, construction up to 10 floor, 12 floors. Such a contract cannot be specifically enforced. So it is debatable. Some courts have said yes, even a joint development agreement is enforceable. But for broad example is you can take where minute details are involved. The court cannot continuously monitor whether the performance is possible or not. You can disallow specific performance. Then where a contract is in its nature determinable. 14C. This is retained after the amendment also. We will see that a contract which is in its nature determinable. Then D, 14D said a contract of performance of which involves a performance of a continuous duty of which the court cannot supervise. This is more or less similar to where the minute details are there, court cannot supervise. Then now the amended provision is contracts not specifically enforceable. There is no change in the heading. But it says the following contracts cannot be specifically enforced, namely when a company has entered into a contract and subsequently becomes amalgamated with another company, the new company which arises out of the amalgamation. So the contract with the old company cannot be enforced by a newly amalgamated company. This is the substitution insofar as 14A. Then 14B, a contract the performance of which the performance of a continuous duty is retained. 14B is retained. A contract which is dependent on the personal qualifications of the parties that the court cannot enforce specific performance of its material terms. Suppose let us take a case of an artist or a painter. So it involves the personal qualification of the person, which cannot be specifically enforced in a court of law. In a contract which is in nature determinable, this again is retained as in the old amended act. So what is contract in nature determinable is again contentious issue before various courts. The Madras High Court has said these kinds of contracts are determinable. Suppose let us take a case of a partnership at will. It is determinable. A license is determinable. So in these cases, there is a clause by which a contract can be terminated. Therefore, the court said don't enforce such contracts, because parties themselves contemplate a situation where a full stop can be put to the agreement. Therefore, don't enforce such contracts. That is 14D. These are the new provisions under 14. If you say, therefore, what has been removed is main 14A, inadequacy test. So the object of the amendment is to do away with the general rule that damages is the rule, specific performance an exception. After the amendment, specific performance is the rule, damages is the exception. That is the major change in section 14. Section 14 has been substituted by a wholly new section. Then 14A, 14 capital A has been introduced, where the court has been given the power to engage experts, like appointment of advocate commissioners or persons who had technical know-how can be engaged by the court to assist the court in arriving at a decision. It is like Order 26 of CPC, 14A. Then the very next amendment is section 16. Section 16 in fact substituted. Section 16 after the amendment is section 16 is only amended. In section 16, clause A was substituted. We all know the suit for specific performance, the pleading and proof of readiness and willingness. But that has been now amended, removing the word plea. So what is required is only proof. So if you see the amended provision section 16, it now reads, personal bars to relief is the heading. Specific performance of a contract cannot be enforced in favor of a person who has obtained substituted performance of contract under section 20, which I will come to a little later. What is substituted performance? A very interesting topic. So if you have obtained substituted performance invoking section 20, there is a personal bar to relief to grant specific performance. Then B, cannot be granted in favor of a person who has become incapable of performing or violates any essential term of the contract that on his part remains to be performed, or acts in fraud of the contract, or willfully acts at variance with or in subversion of the relation intended to be established by the court. So if you are a person who does not approach the court with clean hands, you suppress or you commit fraud, then you are debarred from the relief of specific performance. The major amendment is section 16C. Person who fails to prove that he performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him, other than terms of performance of which have been prevented or waived by the defendant. So the remaining part of section, there is no change. What is omitted is fails to plead and prove. Now it is only fails to prove. But I don't see any major effect because of this amendment, because we all know without pleadings there can be no evidence. That is settled law. So just because the words to plead is removed from section 60, if you want to prove something, unless there is a pleading, you cannot prove. Therefore, I don't see any major change happening because of omission of the words pleading. This is section 16. Then section 19 has been amended. Section 19, they now take care of the new concepts of limited liability partnerships. So therefore, what happens if a company is formed as a limited liability partnership? So that is factored. And if you see, section CA has been introduced in section 19. When a limited liability partnership has entered into a contract and subsequently becomes amalgamated with another limited liability partnership, the new limited liability partnership which arises out of the amalgamation, this is heading, section 19 heading is relief against parties and persons claiming under them by subsequent title. Therefore, a newly incorporated limited liability partnership can step into the shoes of its predecessor and say, you can give me relief, or give relief against the newly incorporated limited liability partnership. This is change in 19A. Section 20 is the most important substitution to the Act. Before the amendment, Section 20 vested discretion with the court to grant relief of specific performance. I will read the entire whole Section 20. Discretion as to decreeing specific performance. The jurisdiction to decree specific performance is discretionary, and the court is not bound to grant such relief merely because it is lawful to do so. But the discretion of the court is not arbitrary, but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. The following are the cases which the court may properly exercise discretion not to decree specific performance. So even the section legislation provided for illustrations, in which cases you cannot exercise discretion in favor of a plaintiff. The first one was where the terms of the contract or the conduct of the parties at the time of entering into the contract or the other circumstances under which the contract was entered into are such that the contract, though not voidable, gives the plaintiff an unfair advantage over the defendant. So if the court feels that by granting the relief of specific performance, the plaintiff is going to get an unfair advantage. For example, let us take an immovable property. On the date of the contract, the value may have been 3 lakhs. The vendor and purchaser may have negotiated for the market value prevailing on that date. For some reason, there is a breach, there is a suit for specific performance, matter gets delayed 10 years, 15 years, when the matter reaches Supreme Court, property price is 1 crore. This has been taken note of by the Supreme Court in a number of cases to hold that its plaintiff is getting an unfair advantage, therefore denies specific performance. Supreme Court exercised power available to it in the Constitution of India and said, you increase the price, we will give you the property, which the high courts cannot do. So therefore, unfair advantage is one aspect which the court can look into to deny specific performance. Then the second one, where the performance of the contract would involve some hardship on the defendant which he did not foresee, whereas its non-performance would involve no such hardship to the plaintiff. So you weigh the hardships accruing to both the vendor and the purchaser. So if you find that the hardships to the defendant, the landowner, is more, deny the relief of specific performance, exercise your discretion. That is the second one. Third one is where the defendant entered into the contract under circumstances which, though not rendering the contract voidable, makes it inequitable to enforce specific performance. Therefore, if the contract is found to be inequitable, court feels the contract itself is working inequity to the party, you deny specific performance. So this section basically vested wide power and discretion in the courts to grant or deny relief of specific performance. Now this has been totally done away with, and the new section 20 has been substituted in its place. Substituted performance of contract. Now what does the new section 20 say? Without prejudice to the generality of the provisions contained in the Indian Contract Act 1872, and except as otherwise agreed upon by the parties, where the contract is broken due to non-performance of promise by any party, the party who suffers by such breach shall have the option of substituted performance through a third party or by his own agency, and recover the expenses and costs actually incurred, spent or suffered by him from the party committing such breach. So this is a new provision, is giving a substantial right to a party to avoid performance with the person who is breaching. Instead, I go to the neighbor, complete the contract through the neighbor or the competing contractor. Thereafter, I can compel or file a claim against the original party who breached the agreement and make good all the costs, the losses you suffered. So thereby, it's a win-win situation for you. Your contract also gets concluded. At the same time, you are also compensated by way of damages. So by doing away with old section 20, which dealt with entirely with discretion, now it is substituted performance of contract. But practically, we will have to see how this is going to work. It may work in a case of sale of goods. So for example, from X from Madras had contracted to purchase 100 bales of cotton from Gujarat from Y. Y was delaying, he was not supplying within 3 months, 4 months. So X feels I can instead buy it from Bombay. I'll abandon this Gujarat guy. I enter into a contract with the Bombay, buy the required bales of cotton. After buying, your contract with original Y does not survive. Therefore, once your contract is completed with third party, you can issue a notice and claim damages. The only rider is you will have to issue a notice giving at least 30 days time in view of subsection 2. No substituted performance of contract under subsection 1 shall be undertaken unless the party who suffers such breach has given a notice in writing of not less than 30 days to the party in breach, calling upon him to perform the contract within such time as specified in the notice, and on his refusal or failure to do so, he may get the same performed by a third party or by his own agency. So the only requirement is you give a pre-suit notice or pre-substituted contract notice saying that I'll give you 30 days time or 45 days time for you to complete the contract. You send me the 100 bales of cotton. If you do not do so, I will go and buy it in the open market. You will have to pay me whatever I suffered, whatever I have incurred. So if you give this notice under 22, you are entitled to sue. Now link it with section 14. So once you obtain a substituted performance, you are not entitled to relief for specific performance. That is 14A. The new amended 14A says where a party has obtained substituted performance of contract in accordance with section 20. So therefore, your requirement of 100 bales of cotton is satisfied. You can't take double advantage and have a contract with somebody, claim damages from, thereafter again seek for specific performance. So that is the object of 14A. You cannot enforce a contract where a party has already obtained substituted performance of a contract. This is very good insofar as movable properties, goods. But how it is going to work when it comes to an immovable property is the larger question. Because Specific Performance Act applies to both movable and immovable properties. There is no distinction saying that this section will apply only to movable, this section will apply only to immovable. There is no such distinction in the Act. The Act is for both movable as well as immovable properties. So let us take a very small example where I contract to buy a property in T Nagar. There is a breach. The vendor does not give me the property. The adjacent house comes up for sale. I go and negotiate, buy that property. After complying with section 22, I give a notice as required under 22, say that I am going to have performance by third party means or through my agent. Suppose you have a realtor who is acting for you. Through him you can purchase another property and say, I purchase another property, you pay me everything. Is it going to work practically in immovable properties? We'll have to wait and see. There is no decision so far insofar as immovable properties. In fact, no decision insofar as substituted performance of contracts. Law is yet to, at least the cases are yet to reach the level of High Court and the Supreme Court. So how can you enforce contract for immovable property? Because the features will be different. There may be so many reasons, compelling reasons for fixing sale consideration. It is always the market prices, willing seller and a willing buyer. So we do not know why that person is selling, why he wants to buy. So therefore, can you compel a person who has breached a contract of immovable property to compensate? You are not going to sell your property, but you are going to be called upon by the court to pay 4 crores. Is it going to be equitable? That is one. So, of course, what is equity is something which cannot be compensated by monetary terms is equity. For example, writ of mandamus, specific performance, injunctions. These are all equitable reliefs. But now, since equity and discretion are now greatly whittled down by the new legislation, the amended provisions, we will have to see how far substituted performance can be practically applied to immovable properties. So this is going to be definitely, it's crossroads. So we already started the journey on the road. This is crossroads. You will have to see how the courts are going to deal with substituted performance when it comes to immovable properties. This is section 20. In section 20A, this is the main object for which the Act was amended. Special provisions for contract related to infrastructure projects. No injunction shall be granted by a court in a suit under this Act involving a contract relating to an infrastructure project specified in the schedule. So I said there are 3 substitutions, 9 amendments and 1 schedule. So one schedule has been newly incorporated, setting out what are infrastructure projects. If you see, it is inserted at the end of the enactment. It is the schedule under sections 20A and 41HA of the Specific Relief Act. The categories of infrastructure are main categories: transport, energy sector, water and sanitation, communication, social and commercial infrastructure. There are various subheads under all these 5 major categories. So if your contract is in respect of any of these categories, then the courts will go slow in granting an injunction. Why? Because foreign investors are afraid to invest in India on the ground of delay. Courts grant an interim order. Interim order is stretched for years together. So they wriggle out of the contract, or they don't want to come to India. So this is one of the major reasons why the Act was amended. Section 20 capital A, special provision was included to cater to infrastructure projects, which has also been defined by a separate schedule. Then special courts. Section 20A, there are special courts to deal with infrastructure projects. It is not, you did not go through the regular regime of filing a suit in the city civil court or high court, appeal. Special courts are to be constituted under the Act by the central government. Timelines are fixed, that the cases should be disposed of in a particular time, maximum period of 12 months and further extension of maximum 6 months. So anybody who wants to litigate cannot extend it beyond 18 months. That is the object of the Act. We have wonderful lawyers who can reach this rule also. So the courts have to be very strict in enforcing these provisions. So far, yes, courts have not been constituted yet. This is section 20, which deals with infrastructure projects. What are infrastructure projects? Special courts to be constituted and expeditious disposal of suits. This is section 20. 20 capital A, capital B, capital C. Then section 22, there is an amendment. It says in addition to, you can ask for the performance in addition to damages. So normally it is either specific performance or damages. But now you can ask for performance in addition or in lieu of damages. That is the amendment insofar as the dual relief is concerned. Then section 40 has been amended. 41, where we saw in the schedule 41H, 41HA is included to injunctions when refused. An injunction cannot be granted. The number of categories, instances are set out. HA has been introduced by the Amendment Act. If it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facility related thereto or services being the subject matter of such project. So this again is a rider for the courts not to grant injunction. When it relates to infrastructure projects, please refrain from granting any interim orders which is going to put brakes on the progress of the project, which is in the larger public interest. So therefore these are the main amendments. Next interesting question is, what is the effect of these amendments? Is it retrospective? Is it prospective? Or is it retroactive? In fact, Parsadi is not here. Probably he's joined us virtually. I had a very healthy debate with him when I was writing the book, because I felt it was prospective. He said, no, Specific Relief Act is procedural law. So it's now well settled law that it has to be retrospective. We had a very healthy debate. Then I boldly gave a conclusion that it is only prospective. Now there has been line of decisions which have now upheld the view that the amendments, even though to Specific Relief Act, which is basically a procedural enactment, which is subservient to the Contract Act. It is a procedure under which the contracts are enforced. Therefore, specific performance is nothing but a procedural enactment. But what the Supreme Court of late has taken a view is, don't go by the nature of amendment or the parent act. See what is the amendment. If it is creating new rights or responsibilities or liabilities, then it is substantive in nature. Once you create a new right with a person, section 20 is a new right. Section 20 substituted performance is a new right. It is not procedural. It is a right which is given to you. Therefore, Supreme Court said it should be prospective, not retrospective. The earliest decision which the first, in fact not earliest, the first decision which touched about the amendment was in the case of Santoshamma versus D. Sarla, 2021, 1 MLJ, page 617, where if you want the equivalent SEC citation also I can give you. 2020, volume 19, Supreme Court cases, page 80. This was the first case where the Honorable Supreme Court had an occasion to look at page number SEC on the page 80. 2020, 19 Supreme Court cases, page 80. So it's the first time the Supreme Court came to address an issue concerning the amendment to the specific effect. But it was only a passing reference. The court did not say anything. It only recognized that yes, there is an amendment with effect from 1/10/2018. Therefore, it was noted. Nothing much happened thereafter in the said judgment. The next decision which touched upon this was Sugar Singh versus Hari Singh and others. Sugar Singh versus Hari Singh, reported in 2021, 17 Supreme Court cases, SEC 705, where Justice M.R. Shah and Justice Aniruddha Bose had an occasion to deal with the amended reliefs, page on the SEC page 705, where the Honorable Supreme Court took note of the fact that there is an amendment, but they opined that it cannot be applied retrospectively, but however we will leave this issue open. So Supreme Court did not decide at that point of time that the act is retrospective, the amended provisions will be retrospective or prospective. They left it open. This was in Sugar Singh. Then a 3-judge bench of Chief Justice Ramana, Justice Krishnan Murari and Justice Hema Kohli in Khatta Sujata Reddy's case, reported in 2023, volume 1 Supreme Court cases, page 355. They went into great detail with regard to this case arose from Telangana High Court. So by then, some of the High Courts had taken the view that it is only a procedural enactment, therefore it is only retrospective. Procedural, it is retrospective. Some courts held the view substituted provisions will have the effect of the original enactment, therefore it can be retrospective. But here the Supreme Court discussed in this decision and held it can be only prospective. The 3 judges bench in Khatta Sujata Reddy versus Siddhamma Setti Infra Projects Private Limited, where a specific issue was raised by the Honorable Supreme Court with regard to the retrospective or prospective nature of the Act, the amended provisions, taking note of the earlier 2 decisions which I have referred in Sugar Singh as well as Santoshamma. The Honorable Supreme Court concluded, I will only read the concluding portions of the Honorable Supreme Court, the 3-judge member bench has held that it can be only prospective. They took note of the fact that various high courts are taking divergent views, and therefore they clearly held that it is going to be only prospective in nature. Para 53, they said, it is clear that when a substantive law is brought about by amendment, there can be no assumption that the same ought to be given retrospective effect. Rather, there is a requirement for the legislature to expressly clarify whether the aforesaid amendments ought to be retrospective or not. Here, admittedly, the Act is silent. The Act does not say whether it is retrospective or prospective. Therefore, the courts had to interpret. In the light of the aforesaid discussion, it is clear that ordinarily the effect of amendment by substitution would be that the earlier provisions would be repealed and amended provisions would be enacted in place of the earlier provisions from the date of inception of the enactment. However, if the substituted provisions contain any substantive provisions which create new rights, obligations, or take away any vested rights, then such substitution cannot automatically be assumed to have come into force retrospectively. In such cases, the legislature has to expressly provide as to whether such substitution is to be construed retrospectively or not. In the case at hand, the Amendment Act contemplates that the said substituted provisions will come into force on such date as the central government may appoint by notification in the official gazette, or different dates may be appointed for different provisions of the Act. it may be noted that 1st of October 2018 was the appointed date on which the amended provisions would come into effect. In view of the above discussion, we do not have any hesitation in holding that the 2018 amendment to the Specific Relief Act is prospective and cannot apply to transactions that took place prior to coming into force. This is now law is settled by a 3-judge member, therefore it will not apply to pending proceedings. It cannot be retroactive also. The concept of retroactive, you may know, is where it started under the Benami Prohibitions Act. Originally they said it can be only retrospective. Then from the date of institution of the suit, make it retroactive. But this is prospective. So it will not apply to pending proceedings. It will apply if the contract is after 1/10/2018. Simple, plain and clear. If your agreement is after 1/10/2018, you come under the new amended provisions. If your agreement is before 1/10/2018, then you fall under the unamended old provisions of the Specific Relief Act.
The criterion, the date of the agreement or the
Date of the agreement. Date of the agreement. Contract. That was debated. That's the way the retroactive was coined by the Supreme Court. Whether it should be the cause of action or date of filing of the suit or the date of the contract. So that in Benami Prohibitions Act they said it is retroactive. It will apply even to pending cases which were instituted after that date. So therefore, here it is clear now. In view of the dictum of the Honorable Supreme Court, it is only prospective, which means it can be applied only to agreements after 1/10/2018. This is insofar as the issue I told you about determinability under section 14. What are contracts that are determinable? Where the Honorable, our bench, our Madras High Court in one case, Murugan versus Rainbow Foundations, discussed and brought determinable categories, contracts into 5 different non-exhaustive, 5 broad categories. Determinable contracts, contracts which are unilaterally and inherently revocable or capable of being dissolved, such as licenses and partnerships at will. So any license is always terminable. Any partnership at will, you can always put an end. Therefore, these are determinable contracts. Specific performance cannot be permitted. Contracts that are terminable unilaterally without cause or no fault basis. These are also determinable contracts. Specific performance cannot be granted. Then second category, prima facie non-determinable contracts subject to consideration on ease of determinability. Contracts that are terminable forthwith for cause or cease to subsist for cause without provision for cure of breach. So therefore some contracts will have a cure of breach. What happens if there is a breach? Then it is not a determinable contract, because there is a parties have contracted for agreed for a cure to the breach. Give them further 30 days to make payment, extend the time. So these are clauses where there is parties themselves provide for a kind of an ovation. Therefore, don't determine such contracts. Then non-determinable contracts, contracts without a termination clause, which could be terminated for breach of a condition but not a warranty, as per applicable common law principles. Then Bombay High Court took a different view. Murugan citation, but it has Murugan versus Rainbow. I'll give you the citation. Single judge, the single judge judgment. A. Murugan versus Rainbow Foundation Limited. The Delhi High Court has taken a different view. The Kerala High Court has taken a different view. Therefore, this again is now causing some concern for enforcement of the new act, the amended provisions of the act, because this also is part of section 14 now. So what is determinable contract? That discretion is now still going to be vested with the courts. The courts have to, because we have already seen at least 4 or 5 high courts taking contradicting views. So therefore, this is again an area of discretion which still continues to be vested with the courts. We will have to see what lies ahead. What road lies ahead is going to be seen. How the courts determine substitute performance. What is the effect of removing pleading and retaining proof alone. But in fact, one other judgment of the Honorable Supreme Court took note of this. Justice Nagaratna and Justice M.R. Shah in Haridasan versus Annapath Parakattu Vasudeva Kurup and others. It is reported in Haridasan. C. Haridasan versus Annapath Parakattu Vasudeva Kurup and others. It is reported in 2023 1 CTC page 605. 2023 1 CTC page 605. Then 2023 1 MLJ page 578 equivalent. Where Justice Nagaratna respectfully disagreed with Justice M.R. Shah, and she discussed the amendment at length, and interestingly she has arrived at certain observations which I will read for your benefit. Justice M.R. Shah said it is capable of being enforced, discretion should be exercised, but since property prices have gone up, you increase the price. If you pay so much, revisit the consideration, you will be given the relief of specific performance.
But how is that fair? Because of tendency of matters in the court,
yes.
they don't take it up.
Now in fact that view has slowly, Supreme Court also is reversing that view. Now they say it is not one of the factors. Just because prices have gone up, you cannot, parties are not at fault. And that is one aspect. So readiness and willingness you still have to prove. You do not, even though now specific performance is a statutory remedy, you're going to get it for the mere asking because discretion is gone. It is the rule, specific performance is the rule. But still, Justice Nagaratna, as rightly says, you still have to comply with section 16. 16 is not amended. Only you say what is removed is pleading is only removed. But she finds pleading without proof without pleading is not possible. Therefore, you still have to plead. Therefore, there is no change in the position of law with regard to section 16. Therefore, I'll read those paragraphs. Therefore, she said, I am refusing specific performance. She disagreed with Justice M.R. Shah and gave a dissenting judgment. Where I will read a few paragraphs from Justice Nagaratna's, where she also deals with the question which Mr. Raja asked me. She takes note of Santosh Amma's case, Sugar Singh's case, and she says the absence of discretionary power under section 20 to deny relief of specific performance, the plaintiff was not entitled to claim such relief as a matter of right. The position of law, even following the amendment of 2018, remains that the provisions of section 16 of the Act have to be mandatorily complied with by the party seeking the relief of specific performance. The relief of specific performance cannot be granted in favor of a party who has not performed his obligations under the contract. It is therefore necessary to ascertain whether the plaintiff has complied with his statutory prerequisites under section 16C of the Act before claiming the relief of specific performance. Section 16, being amended with effect from 1st October 2018, reads as follows, and she extracts the amended provision. Clause C of section 16, which is relevant in the instant case, though amended with effect from 1st October 2018, clearly states that unless the plaintiff establishes his readiness and willingness to perform his part of the contract, he would not be entitled to a degree of specific performance. Prior to the amendment, the expression "who fails to aver and prove" was on the statute book, and its substitution by the words "who fails to prove" does not bring about any drastic change to the object and intent of the clause. This is because failing to prove readiness and willingness to perform the essential terms of the contract would first require averments to that effect to be made in the by the plaintiff. The absence of such averments regarding readiness and willingness to perform the essential terms of the contract would not permit him to let in any evidence on that aspect. It is settled principle of law that no evidence can be permitted to be let in the absence of averments in the plaint. We refer to Justice Ravindran's decision in Bachaj Nahar, 2008, 17 SEC 491, where it's settled law reiterated no amount of evidence can be looked into upon a plea which was never put forth in the pleadings. So that is Bachaj Nahar versus Nilima Mandal, 2008, 17 SEC 491. Then she continues, therefore, notwithstanding amendment to section 16, whereby the expression "who fails to aver and prove" has been substituted with the phrase "who fails to prove," the law remains that no evidence can be let in on a plea that was never put forward in the plain pleadings. But it is necessary to sound a caveat. Even the absence of the words "ready and willing to perform the contract" in the plaint would not have an adverse impact on the plaintiff's case so long as the plaintiff's readiness and willingness to perform the essential terms of the contract could be gathered on a holistic reading of the plaintiff. So therefore, the learned judge says you need not employ the phrase readiness and willingness. Normally we repeat it a dozen times in a suit for specific performance. But even if there are cases where the phraseology is not used, but if you can gather that plaintiff is ready and willing from what is alleged in the plaint, the court says yes, it is enough. Therefore, it is not a straitjacket formula where this is readiness and willingness, this is not readiness and willingness. Then she comes to increase in prices. The reality arising from economic change cannot continue to be ignored in deciding cases relating to specific performance. This was in Saradamani Kandapan. She extracts Saradamani Kandapan, and purchaser can no longer take shelter under delay or non-performance under the principle that time is not the essence of performance of contract relating to immovable property to cover his delay, latches, breaches and non-readiness. Precedents from an era when high inflation was unknown, holding that time is not of the essence of contract in regard to immovable properties may no longer apply. Not because the principle laid down therein is unsound or erroneous, but the circumstances that existed when the said principle was evolved no longer exist. In these days of galloping increase in prices of immovable properties, to hold that a vendor who took an earnest money of say 10% of the sale price and agreed for 3 months or 4 months as the period of performance did not intend that time should be the essence, it will be a cruel joke on him and will result in injustice. Adding to the misery is the delay in disposal of cases relating to specific performance, as suits and appeals therefore routinely take 2 to 3 decades to attain finality. As a result, an owner agreeing to sell a property for rupees 1 lakh and receive 10,000 as advance may be required to execute a sale deed a quarter century later by receiving the remaining rupees 90,000 when the property value had risen to 1 crore of rupees. Then she takes note of this. And she finds that the delay was fatal. Delay on the part of the plaintiff was fatal. She disagreed with Justice Shah and said this is a case where specific performance cannot be granted. So therefore, we must remember that 16C continues to hold the field despite discretion being taken away. So the area is only narrowed down. So you are still required as a plaintiff. You come to court, you plead and prove readiness and willingness. Even though there is no requirement of pleading, you still have to plead. Because the appendix to CPC also, which says you have to plead and prove for a suit for specific performance. The forms are given. It uses the word plead and prove. Therefore, you have to plead and also prove. And you must all remember, specific performance section 16 is a bar to personal relief. We fail to notice the heading. It's a bar to personal relief. Therefore, the impetus is on the plaintiff. Normally, we try to shift the blame on the defendant, saying defendant has not come to court with clean hands. Therefore, he must be therefore he'll give me relief. The importance, emphasis laid is on personal bar to relief for the plaintiff, not the defendant. Therefore, the plaintiff dehors the conduct of the defendant. Of course, there are some judgments where they say conduct of the defendant also can be looked into. But let us assume a case where the defendant remains ex parte. Can you walk away with a decree for specific performance? No. You will have to prove that you are always ready and willing at all points of time. Of course, there is no straitjacket formula to say what is ready and willing. Readiness is your capacity to pay. If you have the money in your pocket, you are ready. If you have it in your bank, you are ready. You have the money to pay the balance sale consideration, that is readiness. Willingness is the mens rea. I find one non-vegetarian here, Abdu is here, non-vegetarian civil lawyer, so I'll use the word mens rea. Willingness is mens rea. So your conduct, what is the conduct you exhibit is willingness. You may have the money, but are you exhibiting a conduct to show that you are willing to complete the contract? That is willingness. So it is twofold. It is not just ready or just willing. It's not one word. Readiness and willingness are two distinct concepts. Readiness is having the financial capacity to complete the contract. Willingness is exhibiting the attitude or the conduct you exhibit at all points of time, starting from the date of agreement till the date of the conclusion of the contract. Therefore, mere readiness is not enough. Willingness also will have to be proved. The willingness is by issuing a pre-suit notice. Suppose you go to the bank, apply for a loan. you inspect the property. All these are steps to show that you are willing to conclude the contract within the time. Next issue again is whether time is the essence of contract. This is always troubling the lawyers and the courts. What is time? Whether time is the essence of contract. Now the court has settled the law. Supreme Court has finally put the nail on the coffin and said, for immovable properties, there is no presumption that time is the essence of the contract. But at the same time, you will have to look at the contract. Again, here there is no straitjacket formula. You have to look at the contract, whether parties intended to give meaning to time being the essence of contract. Suppose the defendant has said, I have my daughter's marriage coming up within 6 months. Therefore, I am selling the property. Even though there is no use of the phrase time is the essence, courts say, yes, it is time is the essence because he was in need of the money. Parties intended to complete the transaction within a period of 3 months to enable the owner of the property to celebrate his daughter's marriage. So look at the conduct, the parties, look at the terms of the agreement to find out. So therefore, it will depend on the individual facts of each case, whether time is the essence of the contract or not. This normally cross words with limitation. See, under Article 54, there are 2 limbs. A suit for specific performance has to be filed within 3 years from the date on which the period contemplated expires. Suppose the agreement says the agreement shall be concluded within 3 months. So from the 90th day, 3 years time is available to file a suit for specific performance. Suppose no time is fixed. There are agreements where the parties don't fix a time limit. Then it is not 3 years from the date of agreement. It is 3 years from the date the plaintiff has notice of refusal by the defendant. Suppose plaintiff gives a notice saying that now I am ready, I have the money. 1 year later, 1.5 years later, defendant sends a reply saying denying his right. Then that is the starting point. He refuses to perform. So take that as starting point, 3 years. So normally we get confused with time as essence and limitation. Both are operate in totally different fields. But this is time is the essence is to see the party's conduct and whether plaintiff can be given the relief or not. Whereas limitation is for filing the suit. Just because your suit is in time, it does not mean that you are going to get a decree. So you still have to make out readiness and willingness under section 16C. So these are the broad categories. The amendments we'll have to see. I think we are, as I said, we are at crossroads. In fact, Justice Call, who gave the forward for my book, he said we are perched at the dawn of a path-breaking era. Therefore, this is exactly what the position we are in today. Even the Supreme Court is not confronted with cases under the amended provisions because it has to go through 2018, suit after 2018, go up to the Supreme Court. Maybe next 3-4 years, Supreme Court will be confronted with a case under the amended provisions. And I would like to end on a very lighter note, since I've probably had you in tight grip for about 45 minutes. When I was sitting in Madurai, there was one lawyer who used to come and attend my court regularly. And he used to bring all my 4 books. Probably he thought I'll have a soft corner for him. No, I didn't say anything. Then one day he happened to argue the case and point touching specifically fact. So I asked my court officer to give me Bare Act. I didn't take my book. And I referred to the Bare Act and I heard the matter. And he was very curious. He asked me, Judge, you have written the book, why not? Why you are not referring to it now? I have brought your book now. I know. You can take my advice, I don't use it. That's what I said. Yes? Thank you. Yeah, Justice Sendil Kumar. Yes. 20? Thank you, Balaramesh. Yes, Rahul.
Thank you, Balaramesh.
28. Courts, special courts dealing with infrastructure projects, agreements. More for the government.
Yes, all PPP projects today come with a termination clause, so they are determinable contracts.
Yes.
Makes this act not applicable to those contracts.
Yes.
What is the use? Is this only an eyewash to show for an interest?
We'll have to wait and see. Probably they did not, they should have removed 14D. It may cause problems. The alternate relief.
Alternately, it is for refund the sale consideration already deposited.
No, you don't affect. In fact, you can ask for both. And after the amendment, you can not only restrict relief of specific performance, in addition you can claim damages, which was not available under the old act. That is not correct. Just because you have pleaded an alternate relief, that does not amount to giving up the main relief. There's a common misconception saying that because I am pleading, lawyers themselves omit to ask for alternate relief. But it can be amended any time. Even pending appeal you can amend, because Supreme Court has now said any stage you can amend and seek for refund.
One good thing is some lawyers commit a mistake. There's no plea will be there. Then from the evidence gathered from other things, that is the greatest mistake.
Amendment, even pending appeal you can amend the plaint, seek for alternate relief of advance. Suppose the court finds that, I think sitting Justice Sundar, we permitted amendment of plaint in the appeal, and then we granted the alternate relief. Suit was dismissed, then appeal, pending suit, jolly well you can amend. Jolly well. Even appeal, second appeal stage you can amend.
The main reason is now the clients are not willing to sign if I put it in the plain that
Because they want the main relief.
That is the reason difficulty in
And they are our paymasters, so sometimes we'll have to oblige the clients.
Franchise agreement regarding franchise of a trademark. And there is a particular clause which says that in case the agreement is terminated for a period of 5 years, you should not use it, or thereafter you should not use it. Suppose there is a breach and the franchisee.
It is a determinable contract, Adama. No, it's a determinable contract. You can't specifically enforce. Because your agreement itself has a termination clause.
My issue is, suppose after the termination, the franchisee uses my mark. Can I go on for trademark infringement under the Trademark Act, or can I seek for specific performance of?
No, only under the Trademark Act.
You can't
come under the specific performance.
I can think for this.
Fortunately, I'm in second appeal, so unfortunately for him, maybe.
In the deposit of balance consideration, two judges are saying that immediately should have.
Not necessary. The section itself is very clear. Unless the court calls upon you to deposit, you need not deposit. It is very clear. Section is very clear.
This is a tilting factor.
Some judges hold it against, saying that you should have deposited. The act is very clear. You need not jingle the coins, you need not deposit the money unless the court calls upon you. So if your court calls upon you and you don't deposit, then the presumption is you are not ready and willing.
In 14, in the old act, is a personal volition.
Yes.
That has been removed.
Oh, no.
Why do you think?
No, here 14, I think it is there.
I think volition is gone out.
Amendment 14. Personal qualification or volition of parties or otherwise from nature. Volition illa. Involves performance. Personal qualification, but they have removed volition. Before amendment, it says a contract which runs into minute or numerous details are dependent on personal qualification or volition of the parties. IPO, it only says a contract which is dependent on personal qualification of parties that the court cannot enforce specific performance of its material terms.
Agreement to
agree.
Volition, I was just thinking about the impact of that.
This is a motivated question. Specific case, because it won't come before me.
Exactly.
I appeared along with him, so. Readiness earlier.
I think whether it is on questions or you are asking any. In that event, you have to pay fees. And my lord, if you are thinking that only advocates are hearing, one more gentleman, Justice Lakshmi Narayan is hearing our lecture in the other side. May I request Honorable Justice Lakshmi Narayan to come over to this A.S.Anand. Time done, sir, okay. May I request former Advocate General Navanitha Krishnan to put a shawl to Justice. Shawl.
Oh yes, it's a great honor for me because I was one of the speakers in the parliament supporting this amendment.
Oh, thank you.
Because my party is supporting this amendment. It's a great honor for me. You can put your photo.
நீங்க உள்ளார வந்துருங்க சார் சார் உள்ள வந்துருங்க உள்ள May I request Kamal Nathan, former President MBA, to present a memento to Honorable Justice. Now the vote has thanks by Secretary.
Thank you, Malak, for the wonderful and excellent manner you presented, which we can just see from the faces of all the people sitting over here. They evince so much of interest, and also certain topics have a lot of intricacies. So he comes with fully equipped and does a lot of research before coming. So we are ever grateful to you. We expect more and more such lectures from your Lordship. We are very grateful. Thank you, members. Please do attend all the lectures and just gain knowledge. Thank you very much. Yes. The next meeting will be on 19/3 by Mr. Senior Advocate A.R.L. Sundaresan on the topic of law of precedents and art of reading judgments. Please do attend. Thank you. Yeah. I also thank the Senior Advocates Forum and the Senior and Mukund is here. NL Raja sir is there. So please do come, sir. Let us have a photo with the Lordship. So it's and we also thank Mr. Parthasar, the convener, and also Somiya, the convener, for organizing. And I also thank Abdu for having, though he is in the criminal side, and he has come and attended. Really. Thank you, Abdu. In a senior, one time, no? Sir, our photo. I also thank the Women Law Association, all the those who have come.